Great. Okay, why don't we call the public hearing to order? This is a continuation of the public hearing with respect to the application for 40B permit on Elliott Street in the town of Milton. We opened this public hearing, believe it or not, in July of 2014. We've had several continuations: September 30th, November 6th, November 25th, December 16th, and January 15th was the most recent. We continued the public hearing until tonight. With the assistance of Mary Fitzgerald, we've kept throughout the process contents of the folder for the 131 Elliott Street project, which lists all of the materials that we've received from various sources throughout the course of the public hearings. And most recently, after the date of the last public hearing on January 15th, we've received two separate pieces of information. The first was on February 27, 2015, a letter from John Thompson, I think he's from the Department of Public Works, and then most recently a package that we received of updated plans and stormwater information, and that was on March 2nd, 2015. This list is part of the file for this application and is certainly available for anyone to inspect, but this constitutes sort of the body of written information, although we've had a fair amount of oral testimony at these public hearings, but this is the body of information, at least to this point, that would form the basis for any decision that the board might render. My name is Brian Hurley. I've acted as chairman throughout this process of the board. With me to my left, Mr. Ted Daber, to my right, Mr. Frank O'Brien, and we have throughout this process constituted the board. We did not close the public hearing at the last session. Subject to the thinking of my fellow members, it would be my hope and expectation that we would close the public hearing tonight. I don't have any particular agenda. We'll certainly we'll welcome anyone that wants to offer any new information this evening before we close the public record, and we'd be delighted to give Kathleen O'Donnell, representing the Board of Selectmen from the town, and Peter Freeman and others an opportunity to speak before we close the public hearing. So I don't really have an agenda, so I'll let you guys take the con here.
Okay, thank you, Mr. Chairman. I can be brief, and I think the topic we want to address is the topic that we left at the end of the last hearing, which is really the main reason why the hearing was not closed last time, and that is the question of the new stormwater management plan and proposal. So the letter that you noted is an important letter, the letter from John Thompson dated February 27th, 2015, and that was responding to our submission of the plans that you also just referenced. So rather than me try to summarize, not being an engineer, I'll turn it over to Phil Cordero from Allen & Majors, and he can summarize basically what we have done since the last hearing and your meetings with Mr. Thompson.
Yeah, thank you very much. You know, at the last hearing, the way we left it for the continuation is that we didn't have a feasible stormwater connection alternative for the project at that time. We had some notions about some, but we hadn't fully vetted them out through the Department of Public Works, both the town engineer and the department director. Since that time, we had occasion to go out and perform additional field work, obtain additional records from the town, from the engineering department, and put forth on the plans dated February 20, 2015, a proposed connection directly from the site through the Central Ave Elliott Street intersection, discharging directly into Pine Tree Brook. And the correspondence that we received on February 27th from the town engineer was that they are amenable to this connection. We have a little more detailing to do with them as we move forward in this process. That's certainly noted. But that was to be expected anyways, given the time frame we were working under. And I think their letter stating that this is a feasible connection, I think is appropriate for the project, and continues to assert that we have appropriate stormwater management controls in place that can support this development. And I'm happy to go into further detail for any of the members if necessary.
Frank or Ted, do you have any questions?
No.
Kathleen, did you have anything you wanted to say
We
on
had
this
just
subject?
submitted the comments as we had asked the DPW in between plowing to take a look at the stormwater. And I've gotten a comprehensive letter, I think, from John Thompson, and which suggests a couple of conditions that the board might want to consider putting into the decision and with respect to applications and approved operations manuals.
Have you, over the course of the last week or so, or a couple of weeks, I guess, I've received, and I think John and Frank and Ted have received also various drafts of a possible decision, keeping in mind that we have not yet deliberated. I take it you've addressed those conditions from the Thompson letter and the most?
No, not the most recent.
Okay,
No.
okay, fair enough. Anything else to present, Peter?
No, that's really all we wanted to present. I was also going to comment on the proposed conditions in Mr. Thompson's letter, which we certainly find reasonable. We had already agreed that we would get the stormwater management permit from DPW. His additional condition is that we submit an operations and maintenance plan, which I presume would be reviewed by DPW to be approved, and that would certainly be appropriate, and we don't have any problem doing that. So we're satisfied with the letter, we're pleased with it, in fact, and now there is a known plan that we hope will be approved by you as well, subject obviously to the final plan approval and all the things we just talked about. So we don't have any further new information or further presentation, and certainly anticipating the close of the hearing, I will just tell you I don't intend to give any great oratory about our position. I appreciate the very thorough and good review so far and dealing with all the testimony and all of that. We do think, by way of perhaps oratory, but I think substance really, and just very briefly, we do believe that working through the board's questions and the peer review consultants that the board has retained and all of the responses that we've made, that we really have taken to heart the issues and concerns that were raised, and we do believe that you have sufficient evidence and then some to find that we've satisfied any concerns that have been raised, and that this would be really a worthy project and add a lot of affordable rental units to the town. And with that, as I said, I will stop, not trying to produce rhetoric, but we do believe that we've met all of the standards of 40B and that it's a project that you can certainly, in good conscience, with good appropriate conditions as has been drafted. I won't get into the decision yet. You've seen that I've had some comments on the draft decision and some proposed revisions, which hopefully we can discuss. But, I would hope that you would feel as we do when you ultimately make a vote. Thank you.
Thank you, Mr. Freeman. Kathleen, is there any information you want to present, or any final thoughts or words that you would like to share with us?
No, I'm just going to be interested to see how this all works out.
Is there anyone here tonight that would like to offer any additional commentary or information to the board with respect to this application? Okay, there being none, I then would propose that we close the public hearing, and we can put that to a vote in a moment. Ted, do you have any thoughts on that?
I would agree. It sounds like there's no more evidence to be presented and no more questions, right?
I don't think there are, Frank.
I would think that after 7 public hearings and a pile of documents in front of me 6 inches thick, I would agree it's time to close the public portion of the meeting.
Well, then I would formally move then to close the public hearing with respect to this application. All in favor?
Aye.
Aye. It's a unanimous vote, and at this point then the public hearing with respect to the application for 131 Elliott Street is officially closed. So at this point, under the open meeting law, we're required to deliberate openly and in public, and we will proceed to do so. So, without further ado, let me just, and I'm not going to engage in a lot of rhetoric either, Peter, this evening. I think I'm going to be fairly brief in my comments, and I look forward to hearing what Mr. O'Brien and Mr. Daber have to say. But I think that this has been a very good process. I think that the board has been very much educated throughout this process. I want to express my appreciation to many members of the public who have come here and spoken and raised legitimate concerns and issues in their process. I particularly want to thank representatives of the town of Milton, the fire chief, police chief, representatives of the Department of Public Works, representatives of the Conservation Commission, one or more town meeting members. We haven't heard from the selectmen, but I certainly know that one or more of the selectmen have been here at various public meetings, and I appreciate their interest in what has been, I think, an important application for the Board of Appeals to address. So I think the cooperation and participation of all quarters has been extremely helpful. I want to commend the applicant and all of the consultants that the applicant has brought forward before us. You have been helpful and very responsive to many of the questions that we have, some of which are informed, some of which are not. But you've been patient as we worked our way through some fairly complicated and difficult issues. I want to thank the lawyers, Peter Freeman, who representing the applicant, Kathleen O'Donnell, representing the Board of Selectmen of the town of Milton, who have brought, I think, valuable insight to the process. It's clear that this project meets all of the sort of jurisdictional requirements of 40B, both in the statute and the DHCD regulations. And there's no question about those aspects. There's no question that Milton is nowhere near the 10% threshold with respect to affordable housing in the town, although I think that's a little bit misleading because I think Milton is nonetheless one of the most ethnically diverse towns around. It just doesn't happen to have DHCD qualifying affordable housing in many instances, perhaps where it could. But that's the situation that we find ourselves in. Obviously, there have been issues, legitimate issues raised with respect to this project. We've touched upon them in the past. I think probably the most significant of the issues that we've addressed over this 7 public hearing, 6 or 7 month public hearing have been the issues of traffic, issues of parking, issues involving fire safety, and most recently the issues involving the way to process and deal with stormwater runoff from the site. I think that we've come to understand those issues. I think that we've had good input from all sides with respect to those issues, and for the most part, I think we've reached the best accommodations and resolutions that we can, given the framework of the statute and the regulations. And so I appreciate those efforts. There is a parking issue in that area. It has always been my view that we can't foist that parking problem onto this project, though. To some extent, it's just an existing condition that we have to deal with in the best way that we can. The applicant has proposed a parking plan, which may not be perfect in all respects, but it's probably the best that can be done under the circumstances. And I think that we've addressed that issue to the point where it is no longer a issue of public safety that outweighs the regional housing needs. So on that issue, I think I'm satisfied that we're in a position where we not only can, but probably should issue a comprehensive permit. The issue of traffic is a similar issue. It's an existing condition. The police chief came in and offered some very helpful and what I thought was very honest testimony about the situation. He ultimately acknowledged that he wasn't really sure that the addition of a traffic light was necessary or appropriate, but it was certainly something that the town might want to consider at some point. All of the expert traffic testimony that we must rely on, as presented to us, seem to suggest that this particular project and its trip generation would not exacerbate existing conditions, and so I think we can make an informed conclusion and decision that that's not an issue that outweighs the regional housing need. With respect to the stormwater issue. I think we've reached an accommodation and resolution among professionals. I'm satisfied that that issue has been addressed. And to the extent that there are any lingering issues that relate to stormwater management and similar issues, I have great confidence that the Conservation Commission, as it goes through the process of issuing an order of conditions with respect to this project, will further address any lingering issues that may exist with respect to this project. The last issue, and it was one, I guess, that probably gave me the most pause because it sort of most directly implicates public safety issues, is the issue relating to fire safety. And the fire chief came in, explained his concerns. I think in part he acknowledged that it had a lot to do with sort of existing equipment in the town of Milton and how it might deal with a slightly different project than I think we're really accustomed to having in the town. But the fact that this building is fully sprinkled and that I was persuaded that there would be access, albeit maybe not optimal access, for fire trucks and firefighters to reach this building. At the end of the day, I at least was persuaded that that issue had been sufficiently addressed, and I pay particular attention in this regard to the Sunderland case that was decided by the Supreme District Court a couple of years ago that in a different context specifically addressed issues of fire safety as a foundation or basis for denying a comprehensive permit. So having gone through those major issues and recognizing that there are many that would prefer some other use and development that's at this site, my inclination would be to vote to grant the comprehensive permit subject to conditions, many of which we've already had sort of presented to us in a very nice fashion in draft decisions, draft conditions that have been exchanged back and forth between Mr. Freeman and Ms. O'Donnell. So to sum it up, I think that the evidence that's been presented to us amply demonstrates that the regional housing need outweighs any particularized issues affecting the town of Milton. And so I will vote in favor of granting the requested comprehensive permit, subject to conditions that we might agree upon between members of the board. Mr. Daver?
Thank you, Mr. Chairman. I also would like to thank everyone for their participation and their wonderful input over these many months that we've had, and the quality of the testimony and the submissions has really been very helpful and very high quality, and to counsel and the consultants and the applicant and the members of the public who offered their comments and thoughts and concerns, also very helpful. And in thinking about this as we were approaching this date, it's very interesting that I basically had marked down the same 4 major issues that, maybe it's not interesting, maybe it's pretty obvious, but I marked down the same 4 issues that the chairman had, and also went through my notes and all the submissions as to how they had been addressed, and parking with the plan that had been submitted in November, and which I assume could be a condition to the to any permit that was granted, and to the engineer's letter with respect to the last stormwater management report submission, and also agree that my biggest concern was the one of fire safety, which was addressed, I think, over the course of a couple of hearings with the fire chief being present. And I had the same hesitation, and I also read the case that the chairman referred to, and was also swayed to a certain extent by the fact that the building will be fully sprinklered and that there seemed to be, I think my memory of, and my notes in the chief's testimony indicated that he wasn't clear that, again, the access was not optimal, but there wasn't any clear indication to me that it would be unsafe the way it was, or the way it's proposed. And so with all of that being said, and without repeating any more what the chairman has said, I think I would also be inclined to vote in favor of the permit. I'm not sure the extent to which we also deliberate on the conditions, but I guess you will enlighten me as to after Mr. O'Brien has his say.
Frank?
Thank you, Mr. Chairman. I want to thank the members of my fellow members of the board for being part of this process since the end of July. I also want to make mention that both the applicant and the town have been well represented, and council have been particularly helpful as we've gone through this particular process, this being the first 40B, major 40B project that the town and this board has had. I also want to thank the applicant's consultants for dealing with my sometimes uninformed questions, comments, etc., as well as the members of the various town boards, departments, etc., who were generously made available to the board through the Board of Selectmen and other parts of the town. Along with my fellow board members, for me, again, the issues came down, or my decision, my concerns came down to 4 factors: traffic, parking, Conservation Commission issues, and then fire safety. And I'll just address each one briefly in turn because Chairman Hurley has done a very good job in addressing them as well. I think that the traffic consultants provided by the applicant, as well as the peer review provided by the town, was very useful. Whatever is built at this particular location is going to add to the traffic situation in the town. It is just a fact of life. But to borrow the words of my chairman, I think what I've been persuaded is that on the traffic side of things, with the testimony of the consultants, the police chief, etc., it is not a showstopper. While there may be traffic concerns and may well be increased traffic, I don't have public safety concerns relative to the traffic. In terms of the related issue of parking, I was strongly persuaded by the survey put in by the applicant showing similarly situated projects in the local area having, relatively speaking, commensurate parking. Parking will be an issue. Parking will have a number of conditions, I would think, in this particular decision. And parking may very well be an ongoing issue in this, for this project and for this neighborhood in general. In terms of the Conservation Commission issues, I now know more about stormwater than I ever knew, so maybe one of these years I'll go to engineering school. But at the end of the day, all of the stormwater issues, other environmental issues, indeed all of the Conservation Commission related issues are solvable. And I saw over a period of time professionals, engineers, et cetera, coming together and being able to come to professionally acceptable conclusions to what could have been some very thorny issues, and quite frankly, issues that were not entirely comprehensible to a layman. But I think that they were solved. At the end of the day, the one particular piece that stuck in my mind that really caused me to have a lot of thought about this particular project was the fire safety issue. I appreciate the comments made by the DPW, the fire chief, other town departments concerning that. I'm in the insurance business, and part of being in the insurance business is evaluating risk. And that is where, going back on my training, is what I did. I evaluated the risk. I'm persuaded, again, through the materials presented by the applicant's fire safety consultant and through the testimony of the fire chief, that a properly sprinklered, fully alarmed building is an acceptable risk. While there may be some access issues in certain portions of the building, after having read the Sutherland decision and after having seen the plans and everything else, I'm persuaded that the fire safety concerns, while legitimate, are not a stopper to this project either, given what the plans provide. So with that, Mr. Chairman, a somewhat long-winded summary, I would be prepared to approve this project subject to the conditions agreed to by the board.
Thank you, Mr. O'Brien and Mr. Daver. It's been a pleasure to join you and serve with you on the board for this hearing. So then I would propose to put to a formal vote then. All in favor of approving this 40B application with conditions to be discussed after this vote. All in favor of that approval with conditions, say aye.
Aye.
That's unanimous. Okay, I don't have any particular sort of knowledge or expertise as to what the next step here is, but I can tell you what I would like to propose that we do, and that is we've received some wonderful drafts. I looked at the most recent one this afternoon, and this was from Peter. It was from Monday, March 2nd, Mr. Freeman, that is, who had gone through Kathleen O'Donnell's most recent draft and then highlighted his edits in yellow on the draft. And I got these magically colored pages here with me tonight. What I would propose to do is that we go through the issues tonight that are raised by these competing drafts, and that we try to address those issues here and now. My memory is that we have 40 days to do a decision, the date we close the public hearing and vote. And so once we go through this process tonight and resolve what we can resolve, what I would propose to do is to take the most recent draft and do one, circulate it to the members of the board, and that we come back one more time for a public meeting, not a public hearing, and then vote on a final version of the decision. That's how I would like to do it, if that makes sense.
Sure, that's certainly fine. I mean, there's a theoretical chance that you could agree entirely tonight, although you wouldn't have the final product, so
Right.
certainly,
The only caveat, the only hesitation I have on that, Peter, is that you might find it remarkable that I haven't read word for word every sentence in this draft decision before tonight. I just haven't had a chance to do
No,
that, and I'd like to do that.
That's fine. I would not
Unless
push
you guys want to sit here and watch me read it.
I would not push you at all, having, we appreciate that a vote's been taken, and, the cockeyed optimist in me, there's been some good back and forth on comments, and so that, I
There's been some
understand that,
great,
that's fine.
in my read of the most recent draft suggested to me that there weren't really all that many issues left.
No, I mean, I had sort of highlighted some I had the basic form, sent it to Peter. Peter sent me some comments, most of which I included, but I did highlight in yellow. So some of the yellow that you're looking at is my yellow.
Okay.
To sort of talk about where Peter had put in, council had put in some language, and we need to talk about that.
Why don't we do this? Why don't you take the lead on this for now?
Can we all make sure we're looking at the same? I have
Right.
like 3 drafts. Is this the one that was yesterday? March 2nd? or-
March 2nd?
March 2nd, yeah.
Okay.
Okay, the one, so we're all looking at the
This
same
one, I have copies here, but unfortunately, they didn't come out in color.
I have one extra in color if somebody
I have
would like
mine
it.
in color. This
I'm
is
good.
this is-
Mine's not in color.
I have the
but
March
it's
2nd
shaded.
draft.
Yeah,
Okay.
And so Peter forwarded a draft, and you can tell if you're looking at the right one, because on the second page, he has added a letter P to number 3.
Yes, I have that one.
So that's the last iteration.
So why don't you take us through where you see the issues are as we go through this draft, and we can talk about them.
Okay, so, the basic information that we had on the first couple of pages, that's just, adding in some dates, adding in letter P, fixing the site visits and all the dates for the meetings and that sort of thing, which I'm sure that, we can that's just fixed. And then Peter had added, section 2 on the jurisdictional requirements and findings, and I didn't have any issue with that, so I incorporated it. I just showed it as blue as his
Okay.
language, which is acceptable to me.
Does anyone, by the way, just to go back for a second, does anybody remember when the site, was there a site visit? Do you remember when it was?
I'm not actually
I
sure
don't
there was a
believe
site
there
visit.
was a site
I don't think there was a
visit, so
formal
that
site
should
visit.
be,
I don't think there was.
Needed.
I know I went to
remember
the
a
site
formal
with
one.
my 3 grandsons, but I didn't remember going with the rest of you guys.
No, I didn't go with those guys.
I didn't know, so I just put
Okay.
it in, so good.
All right.
Okay.
We were all pretty familiar with the site.
I went there
so-
with my law school students, if you want to add that, but
So we have to renumber those, but so let's
Yeah,
just take out that
that's
paragraph.
fine. And
All right.
then, yeah, so then we have to put in I have to put in all the dates of the public meetings and, or deliberated on the application and that sort of thing. So, then we have.
Kathleen, as you go through, it just might be, if you,
Yeah.
when you're flipping, just what page you're
Yeah.
going to, what section you're going to.
I will, so I just had finished talking about section 2 on page 3.
That's
Which
jurisdictional
is the
requirements.
jurisdictional
Right.
requirements and jurisdictional findings which council provided and I inserted. Number 3 is the findings. And those are the findings that we don't obviously have 10% of our housing available to low and moderate income families. We describe the project in number 2. With 3, we say that serviced by town water and sewer. We describe the location of the site, and then in number 5, we would have the option to say the project as conditioned above is or is not consistent with local needs, and your chair has said that he believes that it is, so
Right, and so we voted as a board.
that will
so-
is consistent.
Mr. Chairman, before we go out of that particular section, Roman numeral 3, findings, number 1, the percentage, 4.4%. Is that number in dispute, or am I mixing it up with one where there was some sort of calculation taking in the entire area of the town or something like that?
That's the one
It's a
and a
different
half.
calculation.
That's a
That's a
different
different
calculation.
Yeah,
calculation.
H&W Apartments, there
Has
was
to do
of an appeal to DHCD on the basis not of the 10%, but on the acreage of the land devoted to affordable housing.
Okay, so this number, because of that, this number's correct.
This number is
Right.
correct.
Thank you.
Which is the issue du jour among 40B opponents.
Apparently.
it's now
So
in
I've
Newton
heard.
as well,
Yeah.
a few others.
That's why I asked.
And the 4.4% comes from DHCD information, so.
Yeah.
Okay.
And then the number 4 on page 4, Roman numeral 4, would be the actual vote.
Right.
Um,
So there it would just be grants.
grants.
Right.
And then the conditions start on the following page, number 5. I had a general question for the board as to how this project was going to be reviewed. In some situations, the site plans and the final architectural plans are submitted to the planning director. In some cases, they're submitted to the town engineer. I didn't know, sometimes it's the board. So I didn't
Do they ever go to the
Building
building commissioner,
commissioner?
or building
The building
inspector
commissioner,
too?
so- yeah.
Or
So-
maybe more than one,
Right.
yeah.
Well, I think we have to have somebody in charge.
I think we have to ask, I just want to make sure, that's a kind of a question that comes through here a couple of times, as to who do we want, who's the sort of designated babysitter, essentially, for project compliance. This sometimes doesn't happen at all, but, you do want to have somebody at town hall that's watching to make sure that, you know, things are supposed to be submitted before the building permit is issued. Things are supposed to be submitted before the certificates of occupancy are
Right.
issued.
So if this were not a 40B
Well, how would you normally
proceeding,
do it?
that would be the question. Who would be,
It would be if this wasn't a
Yeah.
40B, it would be the building commissioner.
right, that's,
Okay.
Typically, I've never seen a decision, I've never written a decision that granted anyone other than the building commissioner oversight authority here. I mean,
That's
other
fine.
than
That would be fine
deferral
with
to other
me. Peter,
considerations.
is that all right with you?
Yes, yeah, we think that makes sense because he's, basically, there's combined building plans and zoning
Yeah.
compliance,
So
and it's
we-
all based on what
so
your
we-
conditions
So-
are.
That would be, instead of the town engineer, would be the building commissioner.
Okay.
It describes the project as having no more than 57 units, 49 of which are 2 bedrooms, 8 shall be 3 bedrooms, 5 of the units are fully handicapped accessible. That's all from the applicant's application. 64 standard parking spaces, 4 compact spaces, 3 handicap spaces, and then the 65 underground spaces and the 6 surface spaces as shown on the plans. And then I had put in a number 4, that the applicant was going to have a parking permit system because you had expressed at one of the public hearings concerns about how that parking was going to be managed.
I'm sorry, this is under the conditions?
Yeah, on page
okay.
5.
I mean, can we, there
Yeah,
were,
and
there were
these
like,
are-
yeah,
These
there
are
were,
not, I mean,
Right.
these are just my draft. You
Yeah.
folks can have all the authority in the world
With-
to throw some of this out, modify it.
and put the specific points of the parking plan in
Mm-hmm.
there. Yeah, okay.
As I said, I really provided this as a framework. This
Yeah.
is not.
That's
simple.
great, that's great.
In housing, we put in a provision, obviously, under the statute, 25% of the units have to be have to be affordable. And the planning board chairman expressed the requirement that those units be reserved perpetually for affordable housing, not the sort of 20 or 30 years or whatever would be the usual financing. And then we had put in language, I had put in language to say that the applicant shall make sure that they're put on the subsidized housing inventory. The applicant's attorney would provide instead, as a comment C, you can see that comment in the middle of the page, that they want to have language that said that they'll reasonably assist the town in qualifying the units, and we really wanted to put the burden on the applicant.
My comment on that is, and I think it's somewhat subtle, we have no problem assisting the town in doing all we can do, but to say that the applicant shall ensure that the units are qualified and placed on the SHI, it's beyond our control if DHCD says for some probably purely technical reason that could be solved, I grant you, but if DHCD says, sorry, something isn't right, it doesn't qualify, yes, my language would make sure that we work with you to do what we can, but to outright say, we ensure, that's beyond our control to ensure what DHC does. So that's why I thought that the spirit of my language absolutely is consistent with what Kathleen wants, but I'd be remiss on behalf of my client if I agreed to language that makes them responsible and theoretically in default of the permit for something they can't control.
I still want to say, get on the.
Well, I guess one of my questions, one of my questions
Yeah.
would be, if they weren't qualified, what would be the reason they wouldn't qualify? It would be because there would
Because
be
they hadn't been
something in
writing
the,
to the right people.
something in the submission that wasn't, or,
Or there was some issue about, how they ran the lottery, or how they got the affordable, the affordable tenants, something that wouldn't be in the control of the town. We're not the ones who are leasing these units. We're not doing the intake. We don't know who they, so if they don't count, the reason, it would seem to me, would be because there's some violation of the marketing plan or something like that.
Well, I think that can be bridged by using my language, but saying if the reason that they're not counted is because of some lack of compliance with the state requirements on the part of the applicant, then the applicant shall, post haste do what's necessary to comply.
What, I mean, do towns
Yeah.
typically get involved in this, in qualifying units for SHI purposes?
Not usually unless it's a, local initiative program, where it's a town-sponsored project. Normally,
Well, that, I mean,
it's,
that's not quite true, because actually, even the process of getting them on the SHI is beyond our control. It's the towns that have to submit the request to DHCD to say, okay, we've now issued this comprehensive permit, and please add the units. And after 1 year, the way the regulations work on the SHI, as soon as the permit is granted, affirmatively as it is here, then the town would send that letter to DHCD. So first step is accomplished pretty much right away. If after 1 year, no building permit is issued, then the units fall off the inventory. And then we would certainly, if that's the case, we, God forbid, maybe it's because we're in appeals or who knows what. I don't mean with this board, but who knows what. So, then there have to be future affirmative steps where we would still want to go through with getting our financing from the subsidizing agency, ultimately closing and pulling a building permit, and then once again, the town would make the request to DHCD. So it's not that it's super complex, it's just that it really is beyond our control. So to cooperate and use reasonable efforts and make sure if we're out of compliance with something that we're duty-bound to quickly remedy, I'm fine with that language, but it just goes too far to say that will ensure.
so if we change that language to say that, that the applicant shall reasonably assist the town with qualifying the units, but add in the caveat that you've suggested, that, the applicant's gonna have to do everything it is required to do to make sure that those units.
That's fine,
Comply.
totally fine with that.
Right. Well, yeah,
Split that hair.
okay. I mean, I
Yeah.
thought I also heard him say that if it was something that had to do with the submittal or something, that the word shall was probably okay, if it was something that you could correct.
Yeah?
Yeah, I can't remember exactly how you phrased it, but.
If there's some compliance requirement on us that we haven't met, then we shall remedy whatever you want, diligently or as soon as possible or within 30 days or whatever.
So Kathleen, can you do some language that
Yeah,
you,
I've got-
that you
got
propose in a
something, yeah.
draft? Okay.
And in number 6 was a clause, and this is really up to the town whether you wanted to include it, but lots of towns do, which is that you would like to have some preference to residents of the town. Obviously, those are somewhat limited by the fair housing requirements of DHCD, but it is not an unusual request to have some sort of ability to have some preference to residents that are defined as living in the town at the time of the application to rent, employees of businesses, town employees, households of children, attending school in the town. Obviously, this is always going to be subject to the fair housing requirements, but, to the extent that we could provide some kind of preference for town employees, town residents.
I mean, I personally see no reason not to do that, to give local preference to the extent we can.
No, I don't
Yep,
have a problem.
I agree.
And then what I highlighted in yellow is the language that Peter had suggested, where that, we would have to provide, if DHCD, they change the regulations all the time about this, but, we need to provide some evidence as to the need for a local preference, which I think we could certainly do, given the housing costs in this town and the issues of providing affordable housing for town employees. I don't think that would be hard to do. So I didn't have this is, as I said, I just highlighted as suggested by the applicant, but I don't have a problem with
Okay?
including
Then I would suggest we incorporate it then.
in number 7.
FYI, it just
yeah.
reflects what DHC
Yeah.
now requires. I mean, frankly, in the past, it was almost more the applicant, ironically, but DHCD says, no, the town has to send us their data and whatever, so that's all.
Yeah. And so in page 6, on number 7, was talking about the permanent restriction and regulatory agreement. Language that's in blue is the language that Peter wanted to add, which I didn't have a problem adding. the language that's highlighted is the things that I needed to, the board should consider. And Peter perhaps would like to explain why he believes that we shouldn't include a provision restricting or limiting the dividend or profit of the applicant in our own agreement.
Sure. The first part of it is that the limited dividend requirements are under the Amesbury case, another SJC case, Amesbury Board of Appeals versus Housing Appeals Committee from, I think it was 2010, 2011, basically said that there are two, as a matter of law, areas which are completely within the domain of the subsidizing agency, not a zoning board. And those two areas relate to the affordable housing requirements and the profit limitation. And the court made very clear that those are exclusively under 40B, subject only to the subsidizing agency's rules and regulations and policies. The zoning board naturally is allowed, as you have done tonight and in the course of what we're doing now, addressing typical land use matters, all of those concerns under land use and development issues, but not the profit and not affordability. And that's the Amesbury case. And, you know, so the limited dividend requirement is up to the subsidizing agency, and they have a term of, candidly, I forget if it's 25 or 30 years with this Mass Housing Partnership Program, but it's either 25 or 30 years with a limited dividend requirement. And after that, although we have no objection to the permanent affordability, that's what the town regulatory agreement will cover, and I have no problem with that. In fact, you recall months ago I shared with you a suggested draft of such a town regulatory agreement, which has been accepted by other towns for projects by my clients. So in a nutshell, that's it. You know, I just don't think there's any legal authority for a zoning board to enforce a profit limitation beyond what the subsidizing agency requires.
Kathleen?
Well, I mean, obviously, the most important consideration I have is that it's a perpetual restriction and that those units stay affordable beyond the financing period. I'm certainly familiar with the Amesbury case, and the fact that the regulatory agreement that they're going to have for their financing is going to have a profit limitation. My idea about a regulatory agreement that goes on after theirs expires would include the same kinds of provisions, which typically have those limits. So.
Well, I mean, you know, in that one, I can't agree to it. I've never seen it done beyond what the state requires. And, you know, in the long run, again, clearly the affordability and perpetuity of that is critical, and I respect that. And, you know, that this language absolutely provides that. You know, without getting philosophical, but I also think in the long run, it's, you know, the more incentive a developer has to, you know, to make profit, it's actually preferable for a municipality to have a project where, you know, they're going to put money in because they can get money back, and, you know, and yet it doesn't affect one iota the quality of the affordable housing that's going to be there. If anything, it improves it. So, you know, I think that your interests are well served by the way I have proposed it.
Mm-hmm.
My own view of this, for what it's worth, is that the town's concern is in keeping the affordable housing affordable beyond the term of the regulatory agreement, and I don't really see any reason why the town should be involved in attempting to limit the dividend or profit of the applicant. I would be inclined to go along with that addition from Peter. But
Or if we just took out the requirement of Roman numeral 3, and then he wouldn't need this last paragraph about the Board of Appeals of Amesbury, right?
Well, since it's there, I mean, I'd rather just address it
Okay.
head-on rather than say, okay, you know, we may have to come back to negotiate the agreement down the road. Let's just address it right now, would be my respectful request.
Okay.
But if you put number 3, little 3 in there, then do we need all of that verbiage about
Well, that's what
the
I was
extra
thinking.
decision? I don't see why we would. I don't even know what all that means.
If we took that out, then my proposal was to take out
I
number 3.
don't have a problem taking it out because the case is the case, and the important guts I'm satisfied with. I can tell you candidly that language actually was suggested by town attorney in a different town. That particular attorney added it to one of my original drafts, and so therefore I thought perhaps the town would like it. But if you'd rather take it out, that's fine.
Yeah, I'd
with
rather
me.
take it
Yeah,
out
I'd
because
like
I
to
don't
have
really,
that
I don't really
in
know what
there.
it means.
One of your former colleagues, Kathleen.
I'm sure.
Okay.
I
So
could probably
just-
guess who, too.
So can we go back? Is little 3 going to stay in?
No.
No, I thought it is gonna, my request
thought it
is
was
that
gonna stay in.
Yeah, my request is that it does
Oh,
stay
yeah,
in.
that's right.
Yes,
Sorry.
Little
right there.
3 stays
Yeah,
in.
Little 3 stays in.
and all the rest
And
goes
all the
out.
rest comes out.
Okay, that's fine with me. Is
You
that-
mean the rest of the yellow?
The
Oh,
yellow
so-
comes out,
Yeah.
right.
Yeah, okay.
I had that backwards, sorry about that.
Do we, Frank, you?
Yeah,
you
I'm
good with
okay.
that?
At the bottom of the page on architecture, it talks about the building, they're gonna conform to the architectural plans, they're supposed to submit final plans, and that would be to the building commissioner to determine that they comply with the plans that were submitted, to the board.
Right.
There was discussion about the mechanicals.
Kathleen, before we go,
Yep.
typically, in our decisions,
Mm-hmm.
we use the phrase substantial conformance,
Okay,
because we don't want to have a situation where there is some sort of
Mm-hmm.
technical change from an architectural point of view, and not have the building commissioner have the discretion to
Dismissive.
approve that. Moving a window or something. I
Yeah.
just don't want to have to, just some flexibility for the enforcement authority.
so in the
Chairman, are you okay with that?
Yes, yes. So it would just say the building and the units in the building shall substantially conform to the...
Substantially conform.
Or did you want to end the second sentence where it
Where the
says the
plans-
applicant submits the final plans, whether the plans substantially conform to the architectural
That-
plans?
that's
That's
probably-
better.
that's probably
That's probably
better.
better.
Yeah.
That's probably better.
And then in 10, there was discussion about the mechanicals at one of the hearings, and the applicant has asked for a change to this language, which would say, to the maximum extent possible, the mechanicals wouldn't be visible to the homes abutting the site. And I don't remember what on the architectural plans was shown in the way of hiding the, HVAC systems.
I guess I'm
and
not
all
sure what difference that would make in terms of, because the maximum extent possible would mean that you could do things to make it so that it wasn't visible, So, I'm not sure that it,
Well, I know this is rehashing what was done previously, because I know it's not new testimony, but thank you for asking, and that's what I was whispering to Kurt, because it's his input. I wasn't trying to be coy here. I get concerned to say that, absolutely something will never be seen, and then if it is somehow, there's a violation. What you're suggesting is that it could be screened somehow, as opposed to simply, as the crow flies from the street, and that's, I hadn't even thought of that, and that's logical. Again, this is rehashing what was done, it's not new testimony, but, you guys, if it says, if you have to put up something on above the, on the roof, above the parapet or whatever, that
Well,
would block.
the units sit behind the parapet wall, and they sit back at the center part of the building. So from immediately adjacent to the building, you would probably never see them. However, there are other local streets that rise in elevation from,
But I've only said in this
There's-
language from the homes abutting the site.
okay,
So I'm not saying that
Yeah.
if you're flying over with a
Yeah.
drone, you're gonna
Right.
see them, but
I
for
mean,
the,
yeah,
for the
that's some-
impact on those folks that are on the western end,
Okay,
is
Yep.
really what we're.
That should work, shouldn't it?
that should work.
Okay,
Okay,
let's
good.
just leave it that way.
On page 7, I know that there's an existing enforcement order related to the removal of the tree, I think. And so I just had put in the open space and landscaping that they were going to comply. I didn't really have a lot more details on that. And the applicant would like that clause deleted. The only other provision on the open space and landscaping is to the exterior lighting, and I had said that you wouldn't be able to see any glare. But the applicant would like to add, once again, to the maximum extent reasonably feasible, that glare wouldn't affect nearby property.
On the enforcement order, my thought is just very simple. I think it gets real messy if you have two tribunals, so to speak, that are somehow trying to enforce the same thing, and it's not a question of your domain, I don't mean that. It just doesn't seem practical. We're gonna be dealing with the Conservation Commission. The present enforcement order says something as we work through our NOI in order of conditions we're hoping that there would be something that basically adjusts or changes the existing enforcement order, whether by a contribution or putting trees off-site or something like that. So to me, it's like, well, I sincerely don't think you have anything to worry about, because you know the Concom's gonna deal with it, and we have to deal with it. So it just seems not just redundant, but potentially difficult because of what could be ongoing. That's my, it's not trying to get out of an obligation, but we'll have plenty of accountability to the Concom, if you will.
I tend to agree.
I'm okay with that.
Yeah.
Okay.
Traffic, addressing the issues,
In paragraph 12, that language.
well, that, to the maximum, sorry, I
mean,
should skip.
I think that's okay.
Okay.
Isn't that the most you can ever expect from somebody?
Yeah, I suppose.
Yeah.
In the traffic, when the police chief and the DPW director, we all talked about the traffic potential impacts, and we really weren't sure whether or not this was going to be sort of the tipping point for Central Street and that intersection. There had been some discussion about the applicant contributing an updated traffic study after the certificates of occupancy had been issued, so we now have some idea about what the actual usage and what the actual traffic patterns are once the building is occupied. So there had been some discussion at the hearings about whether we'd have the applicant contribute a sum of money towards a new traffic study once the building is occupied. So I had drafted the language that way, and the applicant has proposed instead that they would contribute $10,000 towards the installation of a traffic light if they did the traffic light within 3 years. But we weren't really looking, I don't think the chief was looking for money for the actual traffic light. I thought they were looking for the money for the study on whether the traffic light was necessary.
My memory of this is somewhat in the middle of what you've just said.
Yeah.
My memory was, and I have a pretty clear memory of this, that
I believe it was your suggestion.
that the chief wasn't committing to even doing a traffic study, much less to doing a traffic signal. And that what we said is that, I know this was my intent. If the town decides that it wants to do a traffic study, then the applicant would contribute the $10,000. That was my understanding of how it would work, because it's very possible, and it would have to have some period of time in which to do that, because I
Yeah.
don't want to hold that $10,000 ad infinitum.
Right.
I had the strong impression from the chief that the traffic study might never happen, because I have a feeling that people don't really think that a traffic signal there is a good idea.
Yeah.
And apparently the warrants that we heard about didn't seem to suggest that it was necessary. So that was my intent, was to say, if the town decides they want us to do a serious study of traffic signalization, then the applicant, within a period of time, I don't know, 3 years, whatever it might be, then the applicant would contribute $10,000 toward that study. That was my recollection of what we were
That's what I
talking
recall
about.
as well.
Is that how you recall it?
Yeah, and that
I
makes
think
more
so,
sense.
yeah.
I don't really want to have the $10,000 only there if we install a traffic light.
No, it was
We're never
my
gonna
idea, it was toward the study,
Right.
was my
Yeah,
understanding.
my memory is the same as yours as to the discussion. In terms of a draft, we thought that it would be better, naturally, for us to just pay it only if the light goes forward. But we're not going to sit here and quibble with that, as long as the time period stays in.
Okay,
Okay,
I
that's-
don't
that's
have a
fine.
problem with the 3 years. So to do a traffic study. Okay. The fire safety, I don't know whether you want to expand that, but we had put in that the, circulation of vehicles, emergency access and signage will be consistent with site plans and conditions of this decision. I don't know whether, given the discussion that you've just had before you took the vote about the importance of the sprinkler system, I don't know whether we wanted to have some sort of further review of that sprinkler system or whatever, or a requirement that there's a sprinkler system included in the conditions of the permit. They're part of your plans anyway, right?
Part of building code requirement.
Yeah, so,
My preference would be to leave that within the purview of the building commissioner, as we would normally do for any other structure.
Right, and that's also, and from what you're saying, I gather you're not objecting to what I struck,
No.
right. Because again, it's all controlled by
Right.
the, you know,
Yeah.
in fact, you folks mentioned that Sunderland case, and that shows pretty clearly what the building commissioner, together with the fire chief, would do. So, yeah, if that's struck, that's fine.
Yep.
That's fine.
Talking about the
Yeah.
wind out language, yeah.
In the stormwater, Peter had suggested crossing out the first sentence, which is of course true, because that was, when I drafted this, we didn't have any
Right.
updates. So prior to the issuance of the building permit, the applicant has to submit a revised stormwater report to the DPW. They could get Horsley and Witten to take a look at it at the applicant's cost and expense. No building permit would issue until the applicant has obtained the approval of either the Concom or DEP under the State Wetlands Protection Act for drainage into Pine Tree Brook, because they're gonna have to have that. Given the letter that just came in from the DPW, I would propose to add the conditions suggested in that February 27 letter about their application for a new drain and excavation in the right-of-way permit that needs to be filed, and the submission of a operations and maintenance plan.
That would be all right with
Yeah,
me.
sure.
Is that okay?
Yeah, absolutely, that's fine.
Yeah.
Okay.
Appropriate.
Number 16, it was on page 8, is really the discussion about the sort of environmental conditions in the site. There's been lots of material provided by all kinds of people on the history of this plant, of the buildings, the underground storage tank. I think there are monitoring wells that probably haven't been monitored in a considerable period of time. So it was my proposal that within 60 days of the decision being recorded, that the applicant would engage the services of an LSP to do a new 21E report, because it's been some time, probably more than 10 years, since anybody's looked at anything in that site. And then I wanted it would seem to me, reflecting all the comments that had been made by various and sundry town officials and board members, that you wouldn't get a building permit until that 21E report, and a clean 21E report had been provided. The applicant's attorney wants to wait until they get an order of conditions for the project, or a superseding order from the Concom, and I don't know how long that would take. And as I said, there's been some real concern about what's going on in that building that people have talked about at all of these meetings. So that's really a board decision as to the timing about when an LSP is going to be there. And then the applicant's attorney has suggested either it's clean or they removed and mitigated, everything that they needed to remove, and I don't have a problem with that. But I do think there's an issue about the timing.
Can I ask you a question?
Ah.
Mr. Freeman?
Sure, thank you. Oh,
No, I was going to ask you a question, but
Well,
that's
go ahead.
okay. Go ahead. Go ahead.
Sorry
You
about
have
that.
something to say.
No, I was just going to say, again, we're not suggesting strike the provision. It is a question of timing, and my thinking is the same as a little bit what I said before about the enforcement order. We're going to be dealing with this with whatever order of conditions is issued for probably right at the demo, as well as the project order of conditions as well. And it just seems a little cumbersome to have a certain time frame that may not mesh with what the Concom is going to do. And there's also some factual reasons why it doesn't necessarily make pragmatic sense to do it necessarily right away, meaning not in conjunction with the demolition, because there's no known or perceived contamination right now. It's true that it hasn't been monitored, but that's because it's under the control of DEP, and there's been no requirement to open up the wells and monitor. There's also the fact
Peter,
that...
I don't even think that's true. I mean, I don't think they've complied with the orders from DEP.
Well, we submitted, and there's been no contrary testimony, we submitted the status reports from DEP, and it attained that result, which until anything further happens with the building, is basically fine. I'm not saying that there hypothetically couldn't be something, but, I think it's not a question of our trying to avoid responsibility. My whole point is it needs to be in conjunction with what's going to happen with the demolition of the building as approved, we presume ultimately by the Conservation Commission. And then the other point, though, is there's some cross-interaction between the town building, you know, those tanks. I think originally the oil that came out was from the town portion. The tanks that are, correct me if I'm wrong, but the tanks are located where again?
And the open parking lot on the corner of Central and Elliott.
Yeah, but
So
in terms of,
the tanks are near, they'd be to the south of the town parcel. And there's a waste oil tank and a fuel oil tank, and they service the building as a whole.
right, so there
There's
were,
questions there that need to be squared away, but to correct Kathleen, there was an oil spill there in '96 and '97. That's the Rizzo Associates report that's been circulated by the town planner and one of the Conservation Commission members. A permanent solution was found for that spill. The fill was taken out of that lower machine room, it's clean, and what they have is what's called an A2 finding. And the only reason they couldn't get background is because the structure is there. And what we're saying is we want to remove the structure, then go in and lift the tanks, and then get an A1 rating, because we'll be able to test around where that cleanup was originally in the lower machine room. So it just makes sense, it's practical, to do this in conjunction with an order of conditions from Concom.
and lifting the tanks is part of it, because that, should there be any issue, you know, it can't be cleaned up until, you know, those tanks are gone. So that's the real proof of the pudding, so to speak. So again, we're not trying to avoid any responsibility, far from it. It is purely a timing issue related to these practical concerns, because when they demo, part of it will be removing those tanks, which, you know, God willing, they'll be secure, and there's nothing there right now in terms of, you know, leakage. But if there is, we have to clean it up under the DEP rules, and then the protocol has to be properly implemented in removal of those tanks, which is under state regs and all, but also really, I believe, inspected and supervised and all that by your fire department. You know, so there's hands-on control, and that's how it'll be done properly. So, again, I don't want to belabor it, but I just, you know, it makes more sense to just not have it here, but simply, whenever it's required under the 21E laws, DEP, and then the order of conditions.
And also, our funding agency, Mass Housing Partnership, requires a 21E report on any loan over $500,000.
Yeah, good point. There'll be a brand-new 21E.
We have to do